The hidden risks of doing a divorce yourself, among those risks are that there are maybe assets that you're unaware of, maybe debts that you're unaware of, which is sometimes even more important, that you could be held responsible for. The other piece of it is, a lot of people think getting divorced is a matter of filling out forms. And if you're going to say or are willing to say there's nothing you want, that you can just figure that out yourself. So the thing you want to look out for is that there should be a sworn statement by your spouse as to all assets he or she has. There should be a sworn statement by your spouse as to any and all debts they've gone into during your marriage. Just because those debts may only be in their name does not mean you have no risk in that. So you need to ensure that you're not going to get stuck with any debts of theirs that you're unaware of. When it relates to custody and child support, if you have children, it's very risky if there's going to be any issues disputed. The schedule with the children, the child support back and forth, the way their lives are going to be structured moving forward. If you're uncertain as to what the parameters of that should be, you can get stuck living with a schedule or a lifestyle for your kids and yourself that you wouldn't even know you were going to be stuck with. And remember, you're going to live with whatever this agreement is for the rest of your lives. So you want to just be really mindful. All the details do matter. If you may be entitled to spousal support, or if your spouse may be entitled to spousal support, in both cases, knowing what your rights are, knowing what the correct calculations are is very important. Sometimes if people are going to get away with not paying something, they think that they'd like to have both parties do it themselves so that they think they're getting away with non-payment. What it really does is opens up future risk that your spouse could come back and say, I didn't know what I was signing. I didn't have an attorney. I was entitled to this. I was forced into it, etc. So there are risks of opening things up again in the future and not having it be final. Some additional things that are risky if either party is representing themselves in the divorce is that there are distinct types of custody, both of which need to be addressed in order for the court to sign off on the divorce. You have legal custody, which relates to all major decisions about the child, religion, medical, educational. And then you also have physical custody. Who's the primary residential parent? Typically, that's the parent that gets child support. You have to know how to calculate that properly. All these things need to be taken into account. There's also very specific language that the court requires related to spousal support, if any, child support, if any. Health insurance is a big topic for the court that has to be addressed in a particular way. So these are some of the things you want to really just be cognizant of related to a do-it-yourself or pro se self-represented divorce. Among the many things that lawyers can be helpful with or even critical for are ensuring that you are aware of all the assets that your spouse has. You also need to be aware of all the debts they have, including ones that may be only in their name, but that you could be held accountable for. There are also very particular ways that the courts want to see child support calculations put forth in an agreement, spousal support calculations, if any, set forth in an agreement. There's also knowing when an expert or forensic psychiatrist or psychologist or attorney for the children may be needed or wanted in a custody case. Those are among the things. There's also the matter of negotiating a financial settlement and knowing which assets you could swap or trade for other assets. For example, if you want to keep the house, but your spouse really wants to keep their retirement, and the different ways that that works, the tax implications of that, how you go about distributing each of these particular assets, whether it's by a real estate sale, the distribution of a retirement asset, which is something that requires what's called a qualified domestic relations order. Again, these are things that require very particular types of language, and our system is not well set up for non-lawyers to figure that out, unfortunately. So unless it's super, super simple, basically no assets involved and no children, there are any number of these things that are risky for someone on their own and things that lawyers do, kind of on a daily basis to make sure that your agreement and your judgment can withstand the test of time. Because the last thing you want to do is get divorced and then have the whole thing be opened up to attack later. Lawyers can save you money in a divorce by cutting through what can be the confusion and overwhelm of the amount of financial information that needs to be analyzed and sorted through, and also the emotion around anything related to children, scheduling, support, and those kinds of things. So while the expense is definitely there with an attorney, it will get done and get done correctly, and will actually save time in terms of pouring through the information that needs to be gone over to ensure what you're entitled to. If you are thinking of trying to do your divorce yourself, call Hannon de Palma. We can have a conversation about what is at stake in your divorce and whether it's realistic or beneficial to you to try to do it that way or to engage the services of an attorney to help you through it. There are the rare cases where it is simple enough and you could give it a try yourself, but don't get too far down the road with an agreement that may not hold up moving forward without getting a consultation. Our consultations are free. Give us a call.